Okay, everybody, let's go ahead and pick up where we left off with regards to courts. Do courts rule the nation? Obviously, they do. What is our first inclination of wherever aggrieved we want to sue, right? So, it tends to create a real reliance on courts, and I don't think that could be argued. We have nearly 1 million lawyers practicing law in the U.S. Over, a quarter of a million cases begin in federal court each year. About only 10% go to trial. A lot of cases are settled or plea bargains. Um, Out of that, more than 50,000 cases are appealed each year, and the Supreme Court will receive about 8,000 appeals each year, but only listen to about 200 cases. Um, this also raises question about the increasing power of judicial elites. We have an overburdened court system, and there might be some instances where justice works for some people but not for others. Plea bargaining is a issue where we make a deal between the defendant and the DA and the defendant's attorneys. Usually, it's done to avoid the costs and delays of a trial, and the defendant can, in a sense, also plead down to a lesser charge, which also would give them a lighter sentence. 90% of all criminal cases are plea bargains. Um, More than likely, people that plea bargain are ones that can afford, the high profile attorneys. Remember, we're all entitled to an attorney, but sometimes the public defenders or the court appointed attorneys have a large caseload and can't concentrate on a case as much as they probably would like. Usually, public defenders are not as seasoned or not as experienced as high priced trial attorneys. So that's definitely a disadvantage. Judicial reforms, we've had judges been accused of crimes. The last judge, L.C. Hastings, became the first sitting judge in more than 50 years to be impeached and found guilty. He was taking bribes, but other judges have resigned under fire. Let's look at the Supreme Court. Obviously, the Supreme Court is the elitist branch of government. Judicial review enables the courts to protect constitutional principles, like we talked about, and being on the bench for life makes them independent of president or congressional influence once appointed, but also they kind of are protected from the voters as well because they're not in an elected official position. So some of the famous Supreme Court cases, and we'll touch a little bit more on this when we get to civil rights. There's obviously Plessy versus Ferguson in the Civil War era that established the separate but equal doctrine. This was eliminated by Brown versus the Board of Education, which desegregated public schools. Griswold versus Connecticut and Roe versus Wade deal with the right to privacy, and that right to privacy is extended in Roe to cover women's reproductive rights. Mapp versus Ohio establishes the exclusionary rule, meaning that any evidence that is collected in an unlawful search cannot be presented in trial. Gideon versus Wainwright gives us the right to an attorney in a criminal case. And Miranda gives us the rights. The law enforcement has to inform us of certain rights that we have with regards to self-incrimination. So at the very top of the court is the Supreme Court, the final interpreter of all matters. They're the ones, like we said, that determines whether or not to accept a case. You need 4 justices to agree to accept a case. They issue a writ of certiorari. We've gone over this. According to the Supreme Court rules, when somebody is trying to appeal a case, the petitioner has a certain amount of time to write a brief not to exceed 50 pages. 50 pages sounds like a lot, but imagine when you're doing a really complex legal argument, those 50 pages might go by pretty quickly because it includes citations, references, and all that. After the petitioner's brief has been filed, the respondent, who is the other side, is given a certain amount of time to file a respondent's brief, and this can't exceed 50 pages. After these initial petitions have been filed, the petitioner and the respondent are permitted to file briefs of shorter length that respond to every other party's respective position. If the U.S. government is not directly involved in the case, the Solicitor General can also file a brief on behalf of the government. With permission of the court, groups that also have a direct stake in the outcome of the case or might be interested can file what's called an amicus curiae, or a friend of the court brief, which provides their own arguments and the recommendation for how a case should be decided. A good example of this would be, say we have a gun rights issue that's coming up. The NRA is within its rights to file an amicus curiae that maybe details their view on how the case should be decided. The Solicitor General will argue cases in which the U.S. government is a party. If the U.S. government is not a party, the Solicitor General may be still given time to express the government's position on the case. When we get to the point where the case is accepted and the petitioner and the respondent are able to go to the Supreme Court, they have oral arguments. Each side has 30 minutes to present its case. You're not required to use that entire time, but mind you, 30 minutes goes by pretty quickly, especially, again, if we're doing a real complex legal argument. That 30 minutes might go by pretty quick, so you need to be concise and you need to be on point. Petitioner goes first, then the respondent. If the petitioner reserves time for rebuttal, the petitioner will speak last. So petitioner, respondent, petitioner. When oral arguments are concluded, the justices have to decide the case. They get a conference together. They hold their conferences on Wednesdays and Fridays. They vote in order. The Supreme Court Chief Justice, which is John Roberts, will vote first. And then it'll go in rank of seniority all the way down to Justice Barrett Comey Barrett being last. So we go in the order. At the top, the Chief Justice goes first, and then the most recently added Supreme Court Justice will vote last. Once each justice is finished speaking, like we said, he casts the vote. Whoever is the most senior judge in the minority will decide who writes the dissenting opinion. Whoever is the most senior judge in the majority will write the majority opinion. So we have two opinions that can come out of these cases. One is a majority opinion, which gives the justices an opportunity to describe their legal rationale for deciding what they did in that Supreme Court case. And the minority, or the dissenting opinion, is written by whoever the senior judge in the dissent is. So we have two sides, the majority and the dissent. The majority agrees with the decision, the dissent does not. If a justice agrees with the outcome of the case, but not the majority's rationale, they can issue what's called a concurring opinion, meaning that they agree with the majority in this case, but for a different legal reason. When there is a tie vote, the decision of the lower court stands. It's not, obviously there might be instances where a Supreme Court justice might have to recuse themselves. And if we only have an even number of justices deciding a case, there's a possibility for a tie. If there's a tie, the decision of the lower court stands. Like we said, the majority opinion, we talked about that. Concurring opinion and dissenting opinion. So we talked a little bit about stare decisis earlier. That's establishing precedent. Legal principles created by a court decision, what provides an example of authority for judges deciding similar issues later. So if we have an abortion rights case that comes up again and it's appealed to the Supreme Court and the Supreme Court takes it on or agrees to hear it, generally they're supposed to use precedent in order to make a decision going forward. Remember, they're not necessarily mandated to rely on precedent. They could overrule or overturn decisions that are made earlier. So one of the concerns right now is for reproductive rights advocates is that Roe versus Wade might be overturned. Justices are supposed to rely on precedent and not touch settled law, but they're not bound by that. So it's certainly a possibility. Now let's talk a little bit about the path to the Supreme Court, and we're going to use the United States versus Windsor case to take a look at this. United States versus Windsor was a attempt to strike down Section 3 of the Defense of Marriage Act, or DOMA. In Section 3 of the Defense of Marriage Act, this was a federal law that defined marriage as a union between a man and a woman. It defined a spouse to be only opposite-sex couples. Eventually, this was declared unconstitutional under the Due Process Clause of the Fifth Amendment, as well as Equal Protection Clause of the 14th Amendment. Let's talk a little bit about their story. Edith Windsor and Thea Spire were a same-sex couple that lived in New York, and they were lawfully married in Toronto, Canada in 2007. In 2008, New York State recognized their marriage following a court decision. Spire passed away, leaving her entire estate to Windsor. Now, we have to also preface this by saying that Spire was an investor in IBM, so you could tell that she probably made a lot of money off of that. And when we look at the tax down at the bottom, you're going to see that she made a lot of money on that. Windsor sought to claim the federal estate tax exemption for surviving spouses. She was barred from doing so because the federal government under DOMA didn't recognize their marriage. The IRS found the exception did not exist to same-sex marriages, denied Windsor's claim, and asked her to pay a $363,000 estate tax. So just off of this tax figure alone, you can probably tell that the money that was left to Miss Windsor was a lot. Windsor filed a lawsuit against the federal government in the District Court of Southern New York for differential treatment compared to other similarly situated couples without justification. So the New York District Court Judge Barbara Jones ruled that DOMA was unconstitutional under the due process guarantees of the 14th Amendment, meaning that a same-sex couple was being treated differently than a opposite-sex couple, and that was a violation of the Constitution. This was appealed after Judge Jones issued an order to the federal government to issue a tax refund, including interest. This was appealed to the U.S. the U.S. Court of Appeals in the Second Circuit. And in a 2-1 decision in October of 2012, they affirmed the district court's judgment, basically saying that Barbara Jones was correct in her ruling. A group called the Bipartisan Legal Advisory Group, who was in favor of DOMA, appealed this case to the Supreme Court. The Supreme Court accepted the case and affirmed the lower court's decision that DOMA violated the 14th Amendment Equal Protection Clause. A majority opinion was written by Anthony Kennedy. He basically touched on some of the differences in the law. When you're a married couple, you can file taxes jointly, and you have a less tax burden than a single filer. You have protections as a spouse under bankruptcy codes. People who were in same-sex relationships at that time, or same-sex married couples, would not be able to receive governmental health care benefits. And there was also a tax saving on health care benefits, as far as the health care that's deducted from your paycheck is deducted pre-tax. Same-sex couples, you didn't have that opportunity. It might have been, it's different in each state, but they might have been able to add as a domestic partner. And I don't know if the federal government level at this time had domestic partnerships. But here in California, at a time before gay marriage was legalized, we had instances where some employers would allow you to add a domestic partner, but the taxation of the benefits would come post-tax, so you're not saving money on taxes. Also prohibits them from being buried together in a veteran's cemetery. Just a little bit more about it. Scalia, who was one of the more conservative judges, he passed away, 3 or 4 years ago. He was basically saying that the court was acting outside of the scope of their power, and they did not have the right to rule whether or not this case was permissible or not. So we look at the path. I think this is one of the real more interesting cases. We started in federal district court. It was appealed to the District Court of Appeals, and then went to the United States Supreme Court. Now, we had a couple of cases that were tied with this. The Perry versus Schwarzenegger case that came out of California that challenged Prop 8, as well as the Obergville versus Hodges case, which focused on state laws preventing same-sex marriages. They were all kind of consolidated and argued at the same time, so the same results were given when we had the Windsor decision made. They consolidated all those cases, so that's why we have same-sex marriage legal now. If we look at state cases, here is the path. We have trial courts, California Court of Appeals, California Supreme Court. If you want relief after your California Supreme Court decision, if your California Supreme Court decision doesn't go the way you want, you can appeal it directly to the U.S. Supreme Court. You do not need to start over in federal court. Just some illustrations about the courts here in the United States. We talked a little bit about the judges in the federal side. Remember, the judges in the state side are subject to voter approval. So Superior Court judges, Appellate Court judges, and California Supreme Court judges are all appointed by the governor, but then have to rerun for re-election unless they want to challenge somebody for their position, which is possible, and which we see. A little bit more, we talked about this during the Asychronous. We have the trial courts, which involve criminal, civil, small claims, Court of Appeals, and then the Supreme Court here in California, where we have one Chief Justice and 6 associate justices. About 8,000 filings a year, and they hear about anywhere from 85 to 100 cases. So discretionary review. And there's some links that you could take a look to see the members of the California Supreme Court and the California Court of Appeals. Okay, that's all what I got for this. If you have any questions, please let me know.